Working with experts is fun. Sure, they're into themselves and think they're the smartest people that ever lived. But don't we all think that we're a bit awesome? There is so much to learn from these PhDs, and they have spent a lifetime studying, researching, writing, and presenting their knowledge to get to the profession of forensic expert. There are experts for innocent guilt phase of trials, but this is not that video. For the purpose of this video, I will only talk about experts for mitigation and punishment purposes. Once the mitigation specialist is in the network of the region, county, or state, call around to colleagues to find out who uses which expert, their opinion on the expert, how much the expert costs. Finding an expert in your state is preferable, but not always available. And there are online expert witness directories, but I never used it. Word of mouth and networking at conferences has been successful for my cases. While attending seminars or conferences, network with experts. Watch their presentations and ask lots of questions. This is vital for other people in attendance as well. In the breaks, introduce yourself and ask more questions. Get the expert's contact information and tell them you'll be calling them for a consultation on a case. See who's willing to give some time to talk about their work. Forensic experts sometimes teach at university or have a private practice along with the service of testifying for criminal trials. Experts are recycled in a number of cases in a specific region. It's the same with prosecution expert witnesses. The mitigation specialist will know who is who within a few cases completed. And once in the field, the mitigation specialist will know which expert to call and for what subject matter. Some experts have written books, interviewed on TV shows, or documentaries. Look them up, research their work, request their resume or CV. Read their publishings. Also, the mitigation specialist can Google some of the capital murder trials in the last year, search trials from all around the country, and research what experts are testifying for the defense. Look up the capital cases, because these types of cases go into the utmost detail for punishment, and most of these cases will have some of the best experts in the field of expertise. The mitigation specialist can research the expert, call them and request information on behalf of the team, ask the expert what counties or states they've worked in, if the expert has availability to work the case, and if there is a court date, give the expert the information to check his or her schedule. Other questions for experts: what kind of cases have you worked on? How did the expert's last trial go? Can the expert provide the name and contact info for the last 3 teams they worked with? Has the expert testified in this county? What court? Does the expert have a copy of their testimony transcript? Does the expert write questions or topics for the attorney to cover? How does the expert handle cross-examination? What things can a mitigation specialist do to prepare for the expert to join a team? Can the expert talk about their past, any criminal history, anything that might be found in a background check by the prosecutors? New experts or finding new experts can be tricky, but sometimes the mitigation specialist can come across a PhD who is willing to work on a case for the first time. For instance, once the team hired a friend of a friend of a friend who had his PhD in criminology and focused his dissertation on the state prison system and treatment of Hurricane Katrina inmates. My client happened to be an inmate at OPP during Hurricane Katrina in 2005, plus one of the thousands who was tried as an adult and incarcerated underage. 2 mitigating circumstances going on here. The expert worked out quite well for the defense team because his research was about 2 major factors in the client's life. The new expert met the client, built rapport, and gave the team loads of research on the treatment of Hurricane Katrina inmates, plus had access to research about sentencing of teenagers. Being an inmate during Hurricane Katrina was a major role in the client's mental condition for years after the storm. And our team learned a lot about the experiences the client survived during and after the hurricane. This information was really helpful in getting a plea offer. If the attorney wants to work with a new expert, someone the DA has never cross-examined, then the mitigation specialist will research online and make several phone calls to find someone to testify. In my example, I met this person through a friend of a friend, and I didn't know him but knew of his academic work. The attorney had to approve the use of the new expert by reviewing his resume and talking to him on the phone. Now, the attorney might have some names of new experts, and the mitigation specialist will research these experts, gather the CV, aka the resume, and payment expectations. Knowing of several experts for different mitigation themes is a really good tool to have. What is even better is having good working relationships with several different experts. The final decision on experts is made by the attorney, and he or she will appoint them to the case. Sometimes the attorney will ask the mitigation specialist to handle or manage this part of the case. The mitigation specialist gathers the CV or resume and pay or fee schedule, sends an email to the attorney, and the attorney goes to the judge and gets the appointment. Then the mitigation specialist gives the expert info about the case, schedules the expert for an interview with the client, emails the chronology, and when the time comes for the expert to work with the client, the team schedules for everyone to hear the findings of the expert after some hours of work is complete. The expert is hired, so now what? The chronology can be given to the attorney to decide which experts to hire if they have a working relationship with the expert. Mitigation specialists work with experts and can do the legwork for the attorney if asked. The chronology is the most important tool. Make sure the attorney has given permission for the expert to see the chronology. Depending on the state in which the crime was charged, the laws about attorney-client privilege can vary, and we don't want the chronology to become shared information with the prosecution. In some states, what the expert sees or writes down is discovery for the prosecution. Do what is best to keep the client's mitigation protected. By the time the team is researching which expert is good for the case, the chronology is well around 80% complete, maybe more, because other records could be coming in or you discover that you need to request different records. This is an invaluable tool in organizing information. The chronology is the timeline of the client's life on paper, and it's all the records and memos organized by time. At times, I have included a huge historical event if it affects the client's life, like Hurricane Katrina. When experts get several records, and there might be 6 or more records from different places, this takes hours to digest and go through. Digesting records is not the expert's job. The cost of experts can easily go through the roof without a chronology. Experts are worth every penny. The team would rather the hours of an expert go to educating the team and jury or spending time with the client. Leave the digesting of records and looking for evidence to the mitigation investigation. If granted enough time by the court, a mitigation specialist has several months to do the mitigation investigation and request all the records needed. Retrieving records is time-consuming, depending on how many records there are and if the mitigation specialist has to request and re-request, or the attorney has to get a court order for the records. Experts are hired or appointed months or weeks before trial. Yes, the expert has access to the records, but let them utilize the chronology first. Then the expert can request for specific records or pages to review, meaning the mitigation specialist doesn't release the records to the expert but has a bulletproof chronology. That chronology is bulletproof because the records have been digested and organized into the chronology. All pertinent records and information for the hired expert were digested at the time the expert was hired. After the expert has reviewed the chronology, the expert might request to review the actual documents. The expert will provide the source of the information as written on the chronology. The records will be electronic and easy to share. Remember, the documents will be what is used in trial as evidence, not the chronology. The chronology tool makes the expert that much more efficient in learning the history of the client because the chronology is all the records organized. The actual evidence is what the expert and lawyer will read from in court. Experts are great to learn from. The best time to learn from an expert is when he or she is on a case. The expert is more available to answer calls or emails because they are invested in the case, invested in the teams. If the expert meets the client and witnesses, make sure to meet with the expert after the interview or interviews. Get feedback as soon as possible. The mitigation specialist might need to write a memo for the attorney on the debriefing with an expert. That's if, in your jurisdiction, the expert's reports are shared with the prosecution. Be clear on exactly what is considered privileged information. Meeting with the expert, the mitigation specialist will download all that he or she found out during interviews. And this is invaluable on-the-job training since every case is unique. The mitigation specialist hears how the expert interviews people and gets their insights on the responses of the mitigation witnesses. Experts have brilliant minds, and that's why they make the big bucks. Some are very much attached, and rightfully so, to their academics, specifically the vocabulary. Not all, but some experts use those expensive words, that intellectual vocabulary. You know the words I'm talking about, the ones you want to ask what that means, but might not because you think that you should already know what it means. This vocabulary is impressive, but we're not trying to impress the judge or the jury. We're trying to educate these decision makers in hopes of mercy for the client. Learning the language of an expert and his or her research is important, so if needed, the mitigation specialist can translate to other team members. Ask the expert questions about everything that you need clarity on. Attending meetings or conference calls, and keep asking questions. Ask the expert to break things down. It doesn't matter if they have to say the same thing 6 times. The info must register to the team before it can be digested and presented to decision makers. Also, don't be afraid to do research and ask the expert about it. The expert wants to be helpful. The expert wants to be used. The expert wants the mitigation specialist to know the basics of their expertise for future mitigation investigation purposes. Remember, the expert is getting paid for calls, meetings, jail visits, and repeating answers and giving examples until everyone is clear. If the expert hesitates to repeat and give different examples on a conference call, then what happens when a jury is hearing it for the first time? The jury cannot ask questions while the expert is on the stand. The info is important to break down way before trial. The attorney's delivery of this information is one of the ways the attorney is building rapport with the jury. The easier the language to understand, the longer we keep the jury's attention, the more invested the jury will become in the case. The goal in the punishment hearing is to present mitigation that will evoke understanding, create connection, and receive a unique sentence. I say all this because experts are human just like us, and we all have our attachments that stem from deep inside. And the mitigation specialist in me sees where an academic person could use these words so regularly because usually they are around people who understand. Also, probably from a young age, their pride and self-worth came from being the smartest in the class, and using these big words is a part of them. So the attachment to such vocabulary has become a part of who they are. I love using mitigation to understand why people do what they do. It leaves more room for understanding and less room to judge them. When utilizing experts in a criminal trial, their expertise are great, and that's why they're hired. But the way the information is presented is important as well, and the attorney can dictate the presentation of the information because it is ultimately their case, their responsibility. Hire the expert based on the mitigating themes developed in mitigation investigation. If there are several mitigation themes in a punishment hearing, find an expert for each subject matter. One expert who speaks on all the subjects, that's a lot to talk about, lots to tie together. Recommend the attorney request the court for a multiple expert, and then whatever the court grants is what the team has no choice but to work with. The team will have to work within the budget approved by the court in court-appointed cases, specifically death penalty cases. There are much larger budgets because the possible punishment of death. The defense requests of the court for the most fair, equal representation of the client. If the judge denies certain expert testimony, it might cause for the case to have an overturned appeal later on. Ultimately, The attorney will decide which mitigation themes are best and what will be used. In the punishment hearing, where the defense only gets one expert, recommend the attorney use mitigation witnesses first, then put the expert testimony on at the end of the hearing. That way the expert can tie it all together and reference the mitigation witnesses if applicable. Experts help verify the life story of the client with science. Experts are hired to educate the jury or judge. The mitigation investigation prepares the evidence for the expert to be successful. They too need the evidence to come to their conclusion. Some experts don't meet the client. They look at research memos and/or records and testify on their subject referencing this information. Other experts must meet the client to testify in the case. One example of an expert that doesn't meet the client is a GIS analyst who specializes in mitigation maps. This expert does chaos mapping, and these maps have storytelling capabilities. GIS stands for Geographic Information System. A chaos map is used by a GIS analyst to explain all the moves the client and school changes the client made throughout life. Plus, this expert will research the demographics of these areas or schools to bring the environment or socioeconomic history of the client into the courtroom. The GIS analyst can testify to the environment the client grew up by utilizing government data. This expert conducts research on social disadvantages using the Geographic Information System. Geographic Information System can visualize, question, analyze, and interpret data to understand relationships, patterns, and trends. And some of the variables that can be mapped are like single mom homes, academic failure, poverty, gang membership, availability of drugs or firearms, lead or other neurotoxins, and more. This expert doesn't meet the client because their information or trial exhibits are a bird's eye view of the situation that was affecting everybody in the neighborhood. And these types of visual aids can be used through the case by other witnesses if needed. This expert is a perfect example of how the expert teaches the jury and doesn't advocate for the client. Another example of a criminal defense expert, let's say during the mitigation investigation, the mitigation specialist uncovers the client had several car accidents or was hit by a truck or got in severe fights, was hit in the head with something, or any kind of circumstance with a head injury. The team will want to consider hiring a neuropsychologist for an expert. A neuropsych is good for other mitigation themes, but for this example, this is about brain damage. The expert will do evaluations to know if the client has brain damage, and the mitigation specialist will have evidence with records and story supporting the appointment of such expert. Story meaning interviews with mitigation witnesses. After the mitigation specialist has done a number of hours of investigation, the attorney can go to the court and request funding for an expert if the client cannot afford to pay for one. Here is another example. During the mitigation investigation, the team finds 3 people who say the client is slow or lazy and gives examples of how they viewed the client's behavior as slow or lazy. Plus, the education records show the IQ of 65 at age 17. These facts alone in a capital murder case would warrant a death waiver. In a non-capital case, the client's intellectual disability is a mitigating factor in the decision and circumstances of his or her life and possibly mitigating factor to the crime. The team will hire an expert on intellectual disability to connect the dots for the jury. The mitigation specialist has the records and stories from 3 people who would be the supporting witness to the expert. Another example of an expert is a consulting expert. If there is an area of the science that the team doesn't understand, the team can hire this consulting expert. They don't testify. They consult the attorneys on what to do. They are hired to consult the team and help find experts as well. Consulting experts have attorney-client privilege because they do not testify. If the mitigation specialist is experienced enough in trial, the two can work together. Experts are appointed and paid to educate the court, not advocate for the client. Mitigation witnesses are closer to being advocates for the client because they are in some degree related to the life story of the client. It comes across naturally because mitigation witnesses have a life connection with the client. Experts are paid teachers for the jury. In lots of cases, the expert meets the client and reviews the records, but that doesn't mean they are paid to say what the defense wants them to say. They connect science to the client's life history. The attorney is asking all the questions. It is in the best interest of the case that the experts stick to educating the jury. The mitigation witnesses bring the emotional leverage needed by their personal stories of the client's life. They cannot help but to do it. They were there. When mitigation is utilized, the attorneys have two powerful components, educational and humanizing links for sentencing. Some experts are storytellers and some are not, just like some attorneys are storytellers and some are not. Pro tip: when the attorney is not a storyteller, they can still be excellent teachers. Support the attorney in his or her strengths. When it comes to experts, depending on the case, depending on the circumstances, this is how, in general, the team works with the expert for the best presentation of information. Being a storyteller means the expert can testify to the science and relate it to life experiences of the client. If the expert relates in general, that is okay too, but there will need to be examples of how the science relates to the client. Relating to the client by giving real-life examples and referencing the mitigation witness that testified before the expert. The expert knows their subject matter and the case very well. If it's easy to converse with an expert, then it will transfer to the jury during trial. When the team can explain things to the expert without struggle and the expert approves, then everyone is on the same page. The team will decide how to utilize the experts who cannot tell a story and doesn't relate the science to the client very well. These experts are valuable in their own way. The attorney literally has to carry the dialogue. The attorney walks this expert through their testimony. These experts are perhaps more technical and not as relatable with their information, meaning they don't give numerous examples and less conversational in their testimony. That's when the attorney becomes the teacher. Boring, redundant, or advanced science concepts is potential to lose the audience, aka the jury. The experts have a tendency to want to put everything out there. This is ultimately the attorney's call. Pro tip: only use what's needed and cut the rest. This is why conference calls, team meetings with experts is really important. All input is welcome, yet at trial, the attorney wants to consider the jury's attention span. Keep the expert on track to their specific subject matter and how it relates to the client's life experiences. The language issue discussed moments ago of experts can be combated with conversational language and visual aids in trial. Trial is where it counts. Trial preparation is when you figure out how things will go. Explain to experts that 8th grade English is helpful when connecting with the jury. The newspaper is written at the 8th grade level. That is the best way to explain the level of vocabulary and understanding for any person interacting with an expert. The jury is the most important bridge to build in a trial. The bridge is between the jury and the defense team. And if the jury doesn't understand something the expert says, they disengage, and we want them to find the client's life interesting. The expert's information can teach a jury something new about themselves. That benefits the defense. The expert can explain things that a mitigation witness will not be able to. See if the expert has the ability to dumb down the language to their expertise to participate in the flow of a trial. Attorneys will want to be the person getting the information out of the expert witness in an organized and unfolding way. Make sure the team is clear on all points the expert wants to cover during their direct examination. If the expert doesn't think they've covered everything in direct, then it's natural for the expert to overcompensate during cross-examination with the prosecutor. Experts on the stand are doing a job. They want to be fulfilled in their job. The expert's job performance is important to the expert. Their subject matter during direct examination by the defense attorney is the most important. Then during cross-examination with the prosecution, the expert is short, polite, and repetitive if need be. Visual aids are helpful with any punishment witness, but incredibly helpful for experts whose subject matter is boring or the expert that is boring. Let's be honest, this is not personal, it's business. The expert can be the best you can get, but it doesn't make them a star witness, engaging, and their subject matter ravishing. Visual aids for different experts. Here's an example. A brain analysis expert is used if the client has the brain scans. The MRI pictures or slides are great for the expert to explain the science, yet for the jury, let's give them a little bit more. When the attorney chooses to appoint a brain analysis expert, ask about a simple, easier to understand poster of the brain to have next to the jury box. The expert and attorney can utilize both exhibits. The poster or slides created by the mitigation specialist look more like 8th grade science and easier to digest for the first-time listeners. The brain scans are good and must be used, of course. Adding another visual aid will ensure the jurors know about the client's brain. Showing the brain both ways is teaching opportunity for the attorney. The jurors don't look at a brain scan every day, so to supplement that with a poster near the jury box is easy. The added poster will be more familiar, as a juror might have children or associate with young people. They might be in college or have attended college before, or maybe they've seen a science book in the last 10 years, where most jurors have not seen a brain scan image unless it's on TV. Maps are visual aids that could help put the juror or decision maker in the time and space of the client's life. It might be a map of all the locations the client lived in 6th grade, or a map of all the family houses in one city, or a map about the distance the client walked to and from school, or even walk across town for work or family. Maps are a good visual aid and important tools for storytelling. For trauma experts, which there's several different types of trauma experts, a map or a drawing can help them visualize the life of the client. One example that comes to mind is a drawing or layout of a house the client lived in during childhood. It's a reference point where different things happened in their house or apartment. Maybe the client drew the layout of the house or another witness does the drawing. The drawing of the house and talking about where everyone slept or what would happen in different parts of the house is powerful in explaining things. Expert witnesses can use pictures of different family members. These pictures are helpful to humanize the people being referred to through the sentencing. For example, the expert might testify about how a kid was raised and by whom, but it's just abstract unless the picture of the parents, aunts, uncles is being shown. At times, experts in their research or expertise on research is presented to preserve the record. The information is so important the jury must hear it, and attorneys are here to do their job and do the best they can. If the jury doesn't understand what the expert is saying, the team can do their best to supplement with info like charts, drawings, maps, pictures, or whatever. Make sure the attorney has these visual aids in time to be approved by the court to be used in trial. Experts who do evaluation of the client will be on the stand longer to explain these tests or brain scans. The timing doesn't matter. The longer any witness is on the stand, the better for the client. In punishment, the jury or the judge, these decision makers naturally need time to get through their emotions after seeing crime scene photos particularly. The mitigation witnesses are buying time for the grieving process of these decision makers. After the jury has convicted the client, a person can be feeling lots of negative or lower vibrating emotions, and the attorney will be taking the mitigation to create an atmosphere of understanding for the betterment of the client's future. This course gives you confidence to build the bridges between expert and attorney, expert and client, and support the attorney in accomplishing a bridge between expert and decision makers. The mitigation specialist uses discernment to find expertise that coincide with the mitigation themes of the case. It's helpful for the mitigation specialist to know all he or she can about managing the case so the attorney has that built-in support system. Now you're equipped to initiate contact with experts, get them appointed, consult with experts, utilize the chronology, and building the bridges between each component of a case from start to finish. Knowing how to utilize the expert makes the mitigation specialist an asset for criminal defense teams. Complete the worksheets to reinforce the details and how to work with experts and how you will navigate your mitigation practice.